But we just formulate it and leave it at that. That once upon the proclamation under 356, all the powers of the government of the state are vested in the president.
Administrative powers.
Yes.
Administrative.
Then can the president, in the exercise of the second proviso to clause D of Article 371,
amend the Constitution?
No, not amend the Constitution.
Yeah.
Exercise the power to grant a concurrence.
Whereas concurrence by what? By which subjects? Please appreciate. Either the applicability of the Constitution, right, with modifications and exceptions, or applicability of list in the concurrent list. That's all. That's all that there is. It can't be more than that. It's my submission to your lordships that when interpreting all these executive orders and the Constitution, three principles must be kept in mind.
Yes.
The first is that the clear language of these provisions in its structural and historical context, the clear language of these provisions in its structural and historical context ought to be given effect. And it is our contention that the language of the provisions is clear, unambiguous, and on its own terms must be given effect. You can't find ambiguity where none exists. So that's the first principle. Second, if there is a textual ambiguity, the court should not be adrift in a sea of pragmatism. And the court must interpret that.
If there is structural ambiguity?
If there is any textual ambiguity or the possibility of trying to find another possible interpretation, let's put it that way.
The court should not be adrift in
the sea of pragmatism.
And
Malaj, the interpretation that is more consistent with our constitutional values. An interpretation that is more consistent with our constitutional values, namely representative democracy and federalism. Representative democracy, federalism, and constitutional morality should be preferred.
Could you repeat that again, Mr. Sibal?
Malaj, that if
Second part.
If there is a textual ambiguity or a possible alternative interpretation by stretching your mind a bit, then, Malaj, we must interpret those provisions. We're not adrift in a sea of pragmatism. We must interpret those provisions consistent with constitutional values, federalism, representative democracy, and constitutional morality.
That's the second.
That's the second.
And the third?
That will ensure the smooth and harmonious working.
In fact, that's the third one.
Of the Constitution.
Written submissions which you gave.
Now I'm just putting it, And the third is that any power vested by or under the Constitution is, in essence, a limited power. There is no unlimited power vested in any institution under the provisions of the Constitution. It's a limited power. It is limited at the point of time when it is exercised. It is limited at the point in time when it is exercised and limited by core constitutional principles or values, both in terms of time and core constitutional principles and values, since no power is absolute and therefore must be exercised in accordance with the provisions. This is my fundamental premise, on the basis of which your lordships, I beseech, will try and interpret the Constitution in the manner that I have suggested.
Yes.
So, if you look at it from the standpoint of these principles, and you apply them to Article 3, Article 356, and Article 371D. Apply these to these three articles. This is the exercise of executive power.
356?
371D. The answers, according to me, are evident. Why? I just presently said. The power under 371D does not extend to abrogating 370 by applying those three principles. The power under 356 does not extend to making non-restorative permanent alterations to the state's constitutional status. That's on 356. And the power under Article 3 does not extend to effacing the character of the state into a union territory. So therefore, it is the interaction,
Yes.
interactive dimensions, the interaction of the values of constitutional values and federalism, separation of powers, and democracy itself that are at play. And that's with greatest respect how, Mullahs, your lordships, be kind enough, Mullahs. And therefore, Mullahs, the question that arises is there a limit to the emergency power, or is it unlimited? That's what they are trying to do in using 356 to change the whole structure. So is it unlimited? Can emergency be passed to used to make permanent constitutional changes? Is it an unlimited power? Can it be used to make permanent constitutional changes, permanent and irreversible? And can the constituent power be equated with ordinary powers, effacing the source of their authority? Constituent power is a separate genus of power. Can it be equated with ordinary legislative power? It can't. And can constitutional change, last of all, happen without consultation with the people, despite consultation with the people of Jammu and Kashmir, despite an express provision in that regard? And last of all, can the state be downgraded to a union territory by the union on its own whim and fancy without consultation with the people affected? Those are the constitutional parameters that I respectfully state should apply when dealing with this momentous change that was brought about by exercise of majoritarian executive power. Time and again in the history of this country, 356 has been misused by all regimes. That was never the intent. And now, in this, in changing the structure of this constitution as applicable to Jammu and Kashmir, it has crossed all limits. See what happens. 20th of June, Mullahs, 19th of June, sport withdrawn. 20th of June, governor says, and suspended animation. 20th of November, an attempt is made. Well, there is some ambiguity in that, to form a government. 21st November, dissolution. Can't be done without the aid and advice. Then, after 21st November, 19th December. Then 356. Then 3rd of July, extended. Then 5th of August. Where are the steps for the restoration of democracy? Where are those steps? In fact, the steps are just to the contrary, the reverse of it. Destruction of democracy. People are not taken into account. Their views are not taken into account. You arrogate to yourself the powers of the state. You arrogate to yourself the powers of the legislature. Parliament becomes the spokesperson of the people of Jammu and Kashmir. And you express the wishes of the Jammu and Kashmir Assembly through Parliament. When the Constitution requires you to take the views of the state, of the legislature, of the people of Jammu and Kashmir, who gave to themselves the Constitution of Jammu and Kashmir. Everything that is done under 356 is contrary to the basic principles of both federalism and democracy, and to the principle of constitutional morality. This is not the only power that you can exercise under 356. There are incremental steps to be taken. This is not a guillotine provision, and it's temporary, to say the least. So unless your lordships come down heavily, that 356 is not meant for this purpose. The excessive use of power also amounts to illegal, irrational, and mala fide. So your lordships will have to determine, was this not an excessive use of power? And per se, it would be illegal, mala fide, and irrational. Hence, it is urged that the doctrine of proportionality is relevant in this context and has to be applied in such circumstances. To appreciate, that's why I said, in normal circumstances, dissolution would never happen. First, the assembly would be suspended, be in suspended animation. Attempts would be made to form a government. In the meantime, you exercise president's rule. When you realize that it's just not possible at all, it's then at that stage that you dissolve the assembly and order elections. Now, you've dissolved the assembly. When did you dissolve it? On 21st of November, 2018. And we are where? In August 2023. Was that meant to be, under 356? On the 21st of November, the governor had no power to dissolve parliament. He could only do it under the on the aid and advice of the Council of Ministers. So see what they did. They knew that the Council of Ministers would never advise the governor to dissolve. So he dissolved it on his own. So if you dissolve it on your own, what are you left with? Only the governor. And then the governor, Malads, did what he did. You impose 356 and then you take over the powers. And Malads, ultimately, you are a delegate. 356 delegates the powers of the legislature to you. You're not an omnipresent, omnipotent authority to do what you like. You're a delegating. You've been delegated the powers of the legislature. What the primary institution cannot do, the delegate cannot do. So therefore, 356 was an extraordinary provision, allowing a progressive pathway for restoration. This is the case where the Queen was advised to prorogue Parliament, and 11 justices came down heavily, unanimous judgment. You can't just shut away discussion in Parliament. This is an extraordinary interpretation, showing that, look, you can't just show your back to the constitution, to the constitutional authority which has to deal with these issues. I mean, in our constitution, the right to prorogue is also given to the government. But of course, this principle is not really applied often.
So, Sibal, in a similar discussion, we'll find in a 7-judge bench judgment in Krishna Kumar Singh,
Yes.
on the power to enact to promulgate ordinances.
Yes.
And the question was,
Your Lordship have said
yes,
in that judgment.
can you, though the power is limited by duration and time,
Yes.
can you bring about irreversible changes
That's right.
by the exercise of the ordinance making power? And we said you can't do that.
I've relied on that. Absolutely. If it were an act of Parliament, right, Malad, the situation may well be different. Because then you would have to attack the legislation itself, if at all it is permissible. But you're doing something through your prerogative power and making structural changes in an embedded constitutional structure recognized by Parliament then in 1950. That's the problem in the case.